I'm actually going to ask the secretary to call the roll, just because I know we have people on Zoom and with just our situation. So if you'll call the roll, Mr. Secretary.
Thank you, Mr. Chairman. Wiggins.
Here.
Branning. Barnett. Barrett. Blackman. Boyd. DeBar. DeBar is online. He clicked off. He was.
I don't guess he's here.
England.
Present.
Hobson. Kirby will be absent. He's not online, correct? McCon is here. McDaniel. Parker. Simmons, 12. Turner, Ford. We have a quorum, Mr. Chairman.
Okay. Thank you, Mr. Secretary. All right, appreciate y'all being here, and just a couple introductory comments. We have a lot of bills that have been assigned to the committee. We will have, like I announced, a meeting on Monday at 2:30, and then, of course, deadline day is Tuesday. And so I know a number of y'all have talked to me about your bills. Please continue to do that. So on today's agenda, I'm going to skip around. We have some guests here, so I'm probably going to get to that first. We'll go with the easy one first. I'm going to call up Senate Bill number 2324, bad faith assertions of patent infringement. That is simply extending a repealer to 2025. There's no changes to the bill. There's nothing, and that bill was something that was passed a few years ago, where there is, I guess, online. This is supported by the bankers. Online people are taking people's patents and really sounds like extorting money. But this was a good law, and this is simply extending the repealer. So the motion is title sufficient, do pass. Any questions or any debate? All in favor, say aye. All opposed? Okay, thank you. We will go to Senate Bill 2434, Capitol Police Transfer of Department of Public Safety. And we have Commissioner Tindall on the line with us. And just real briefly, this one, okay. In short, what this is doing is transferring oversight and operations of the Capitol Police from DFA to DPS. And this was, the Lieutenant Governor has made this certainly a position of his, and in light of what happened at the Capitol in DC a few weeks ago, everybody felt, including the commissioner, that allowing DPS to have control or to oversee the Capitol Police would be in everybody's safety and the best bet. Also, you have the proposed committee sub, which is allowing it to take effect, instead of passage, to take effect May 1st, because talking to Commissioner Tindall, it needs to ramp up in terms of cost and things like that. Also, the bill has in lines 88 to 94, there was that has language where DPS is authorized to work with Madison and Rankin counties. So with that, Commissioner Tindall, do you have anything to say on this? Okay, any questions?
I have a question, Mr. Chairman.
Yes, Senator Blackman.
Thank you, Mr. Chairman. Will the Capitol Police be under Department of Public Safety?
Well, my Commissioner Tyndall, can you, go ahead. Okay, any other questions? Do I have a motion? Motion's title sufficient, do pass. All in favor, say aye. All opposed? Oh, committee substitute, right? All, okay, motion passes. All right, next, since we have Commissioner Tyndall with us, I'm going to go to call up Senate Bill 2253, which is authored by Chairman Fillingane. In the bill, the operative language is in section 25 of the bill, line 400, and in short, we currently have a concealed carry permit and your driver's license. You have two different ones. What this is doing is allowing a person to choose to have it on one license, on your driver's license, to say, you know, your concealed carry. As far as I'm concerned, that's efficiency, keeps us from having to do that. And the rest of the bill is actually just coordinating the language to comply with provision number 25. And I think this is going under what the Commissioner's office has done on our driver's license things. So with that, Commissioner, if you want to say anything, please do. Okay, do I have any questions? Go ahead, motion is title sufficient, do pass. All in favor, say aye. All opposed, motion carries. All right. All right, next one, let me go to, let's go to call up Senate Bill 2483. And I'm going to turn that over to Senator and Vice Chairwoman Branning. Electric bicycles, classify them, and we have Senator Whaley here who authored the bill, so he can answer any questions on that.
Thank you, Mr. Chairman. Senate Bill 2483, the purpose of this is just to define how we're going to treat electric bikes under our traffic laws and to provide clarity to the public and the manufacturers. In general terms, this bill specifies that electric bikes are not motor vehicles, but are going to be treated as human-powered bikes as we know it. And so I'll draw your attention to Section 1. It creates the new law, specifically lines 42 through 47, kind of gives a description of an electric bike. And if you are curious, I had to look the definition myself. Let's move to line 151 specifically. An electric bike is a bike equipped with fully operable pedals, a seat, an electric motor of less than 750 watts. And it breaks it down into three different classes. But this bill basically says that electric bikes can be ridden anywhere bikes can under current law. And line 70 and 71, it leaves power to the local authorities to prohibit these bikes at any place. If a city has a bike path through their city and they're not comfortable with the bikes or any class of the bikes, they're able to sort of control that at the local level. That's the explanation of the bill. I'm happy to answer any questions.
So either you can answer or I'll let Senator Whaley. The reason we're doing this is because of other states have done this, and to allow the these which apparently have become very popular to be not regulated or only regulated as bicycles and not motor vehicles. And Chairman Whaley, you want to address it? Yeah, if you'll get to the mic since we've got people listening.
Yes, sir, Mr. Chairman. You're right on track with that. These things are growing in vast popularity, and we realized it last year when we passed a bill out of the Wildlife, Fisheries, and Parks Committee allowing them to be used on wildlife management areas. One phase where the popularity is soaring is with hunters because of the ease of access. And another area where they're becoming very popular is with elderly people because of the assistance that's provided with the electric motor that is operated off the pedal. It increases the ease of effectiveness, and that's basically where it's going with it.
And I was told that I guess it increases tourism, or certainly that, you mentioned the wildlife stuff, but tourism and bike paths and things like that.
I agree with that. You look at from a elderly perspective, you allow elderly people to get out and enjoy something more, so that's definitely going to increase tourism.
Okay, all right. Senator Parker has a question.
Just one question. You mentioned the word older people. I believe you're the youngest person in the Senate, and so older, by your definition, someone older than you would be how old?
I don't remember making that. I said elderly people. I don't remember saying older
I
people.
thought I heard older. So.
If I did, I didn't mean to.
Thank you, Senator Wayland.
All right, any questions? Do I have a motion?
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye. Aye. All opposed? The ayes have it. Thank you. Thank you. Let's see. Okay, we have Senator Horn on the line. I'm going to call up Senate Bill 2792, which is a double referred bill sent to us from Labor. And if my recollection is correct, that it may have been Judd B., but last year we took up this bill. I think it was passed, but it's the Fresh Start Act of 2019. And let me see. Senator Horn, do you want to say words on the bill? Okay, let me, I have a question. So, we've heard about the Mississippi's workforce participation, and I guess the low percentage, if you will. And this is trying to get, as you said, to not allow a prior conviction to be the sole reason for being denied a job. And this is allowing these folks to get back to work. Is that an accurate statement? Okay, thank you. Any questions for Senator Horn? Or, okay. Do I have a motion? The motion is title sufficient, do pass. All in favor, say aye. All opposed? The motion carries. Thank you, Senator Horn. Let's see. All right, let's see, going to, Senate Bill, call up Senate Bill 2456, open meetings law, and for some of our, I'll explain this, for some of our, I guess our newer members, back when we had issues, with the hospitals, we passed a law stating what things could be used for executive session. And what we had found out was that there were hospitals that were not, they were hiding things and all that kind of stuff. So we reformed that law. And then what we found out is that even though we passed it, that there are still some hospital board of trustees who are, or certainly the supervisors who have chosen not to, or have been interpreting the language that we had before as not applying. So what the bill is doing is simply making clear that executive session applies in those instances. And you'll see, I'm trying to find it. In one particular case, what's been explained to me is that actually our largest hospital has a committee that handles these type of things. And so that language is to address the committee to apply there instead of the whole board of that. So with that, I'd be happy to answer any questions. Senator Parker?
Thank you, Mr. Chairman. Make sure this is on. Thank you, Mr. Chairman. I'm not sure if this is on. I know last year when we were presenting some bills, I had some detailed discussions with Chairman Polk about this issue, and as I read this, it seems to affect or impact that hospital situation. But I believe—
Good or positively or negatively?
I'm in favor of the bill. Okay. I'll start with that. My question, though, is, we have several boards around the state where we have legislators and we have other participants on the board who are non-voting members. And it's my understanding that sometimes those meetings can go into executive session, and there are discussions had, and I believe that was the gist of what Senator Polk mentioned. Is this the same kind of issue but kind of flavored towards the hospital situation, or can you elaborate?
Yes, I can elaborate. The way the bill is drafted is particularly addressing Board of Trustees for hospitals, but if you look at Section 18 and 19, I'll answer it this way. If you're asking, are there issues with how executive session gets called in these different boards and all, I would agree with you. And I will tell you that the code section is open. And so, and the language that starts at lines 18 and 19 was trying to address maybe some of that. where if you notice it says, a summary of the reason for holding an executive session shall be stated in the open meeting, and the reason so stated shall be recorded in the minutes of the meeting. The way the current law is, and the way it's, well, at least the way it was being, I've seen it applied, is they go, oh, we're going into executive session, and then they go into executive session and state the reason why they do it, and the public, to be quite honest, and people don't understand what's going on. You have a lot of complaints. I've received them. So that language, I think part of the problem has been the procedure, which I hope 18 and 19, lines 18 and 19 are trying to address it, that these boards, in short, before you can go into executive session, you have to state the reason to do it. And by the way, those reasons are contrary to what I think is done, are only what's listed in the law here. And as it pertains to Board of Trustees, it's only for particular instances, okay? And so before they can go into executive session, they have to state it on, put it in the meeting and all that, and then there's another procedure. So I hope I'm answering your question. The idea is to, yes, I think that this procedure has been not followed like it needs to be.
And thank you, Mr.
Is
Chairman.
that, maybe that's what you were
That's-
trying to get at?
Right, and the purpose of the question was to bring some discussion on the issue. I realize you have a specific issue here you'd like to fix, but I think this type of issue is something that will impact you, so it might be something we can work on for next session.
Well, code section's open, so, but yeah, that's good. All right, Senator Turner, Senator Hobson.
I'm sorry, I'll be recognized at the appropriate time.
Senator Turner Ford. No? No, okay, go ahead.
Thank you, Mr. Chairman. It's been a while since I looked at this. What is the, I guess, the theme of the language that has been deleted?
Gosh, I'd have to pull it, but it was honestly convoluted. But it says that the deleted language says, any member shall have the right to request a motion, to request by motion a closed determination upon the issue of whether or not to declare, so they request a motion to go into session of whether or not they should do that. And this may be what Senator Parker's talking about, what I've seen happen is they go, we're going into executive session. And the purpose of the change is to say, okay, why are you going into executive session first before you go into executive session?
So I think the question that I have, because as I understood it, that a board could go into closed determination to decide if they want to go into executive session, and they would do that to the exclusion. People, I guess the public would have to leave. And they could, so are we?
Well, that's
do
how.
they have to reach the reason, determine the reason for executive session in open meeting, or can they do it in closed?
So the closed part is how it operates now, is my understanding. And so, yes, they would have to state a reason why they're going into executive session. And then when they go into executive session, then they can go through that procedure, which is in Section 2 of the bill, I think.
So the board has to go through this debate in open meeting and reach a decision to determine if they're going in executive session, and all of that has to be done in the open meeting. Is that what we're eliminating, the closed determination
If you look at
part?
line 16 of the proposed committee sub, it says, any member shall have the right to request by motion an executive session. And then a summary of the reason for holding it shall be stated in the open meeting, okay? And the reason so stated shall be recorded in the minutes. So any member can make the motion, and then, yes, they can say, what are the reasons, and it's listed in the law as to the reasons. And I think what Senator Parker was going to is that sometimes, if not a lot of times, they go into executive session for reasons other, at least that's what it appears, other than what's in the law.
I think my concern is, and I guess it would just be an example, what if it's debatable whether they should be in executive session or not? Do they have to make that decision in the open meeting? If
If I
this
underst-
passes.
Yeah, yes. Sorry. They have to make the motion in an open meeting, yes.
Maybe Chairman Hobson may have
Okay.
something that may be.
Chairman Hobson?
Thank you, Mr. Chairman. Senator Turner Ford was going into the questions that concern me. As I appreciated, and I think there are a few others on this either call or at the committee meeting itself that deal with public boards. I do frequently, and I know others do as well, but the general practice is, and I don't have the bill in front of me, so my apologies, and I'm talking about this without the bill in front of me, but the general practice is that one member can ask to go into closed session because they may have something salacious, let's say, or they may need to discuss an issue about a particular person as an employee that you certainly don't want to bring up because character, competence, health, and performance, job performance are areas of where a public body can go in and discuss somebody. And there are other things too, litigation. They may not want to discuss any of the merits of a very controversial case or a negotiation for a piece of property. Those are just a few examples. So I think the way it's been, I need to look at the wording, but the way the practice has been, at least the public bodies that I represent, is one person does call for the closed session, and then you go into a brief meeting to say, what is the issue? And that's where they generally rely on us as attorneys to say, is this something that is an executive session matter? Frequently, I have to say, no, that's an open session matter. You cannot go into executive session to discuss this. If you want to discuss somebody's pay, or you want to discuss something that's not to be included in the separate statute on executive session. So I occasionally have to tell them, no, you can't do this in executive session. But if there's something that applies, one of those provisions that you referenced earlier, Chairman Wiggins, that applies, then I say, yes, that is something you can discuss. And then we come out of closed session, and there's a public announcement made, usually by the board president, to the public that says, we're going into executive session to discuss items 1 and 2, or whatever they are. And then the public knows at that point. So again, maybe there are some boards that are not doing this the right way, and if they aren't, then shame on them. But this law, maybe this law is correcting or putting in place what I'm talking about. But I think if you do it the way I just explained it, it works pretty well. It really does. The public has a right to know what the topic is at least. They may not know the details of the topic. They don't know that the employee, for instance, was doing something on the job that was salacious, but they know that we're talking about that particular employee or someone in that class of employees. Thank you, Mr. Chairman.
Okay. Yeah. I think Senator Hobson, if I may, I think you're right. There are places that aren't doing it right. And if you have competent counsel and all, but the problem is, based on comments that I've heard and from different organizations, and I'll be honest with you, and I'm not shy to state it, the Press Association, who has supports this bill, and from constituents say that the boards, how it's being done, it leaves questions as to why they're going into executive session. It's public bodies, and so it's not. So it should be limited as possible. And if it's, but what I hear you saying is that it is, when it works fine. The problem is, I think that not everybody's doing it, and this is trying to correct that.
Okay, and again, my apologies, I don't have the bill in front of me, Mr. Chair, but I will, if it passes this committee, I'll look at it with you, because I do have a lot of thoughts on this particular matter and a lot of experience, and I know Senator Black, when I see her online too, she represents some public bodies as well, and I'm sure she does. There may be others in the room, but I'm happy to visit with you, because I want to make it as good as possible too, but I don't want it to make it.
Well, I will tell you, the chair's open to having an amendment to restore the language, to restore the language that was deleted, to be quite honest. So if anybody wants to make that motion.
What language, if you don't mind me asking, Mr. Chair, what language was deleted again?
A closed determination upon the issue of whether or not to declare an executive session. The motion by majority vote shall require the meeting to be closed for a preliminary determination of the necessity for executive session. That's what was deleted.
So back to Senator Turner Ford's questions, you would actually have to have a debate in the open session as to whether or not you wanted to go into executive session.
Well, based on the discussion we're having here, that's what we're talking about, and that's what I'm saying is to restore, the chair's open to restoring the deleted language. Right, and keeping the, okay.
Well, I'm going to defer. Senator Turner Ford is there at the meeting, I think, and I think I'm thinking along the same lines as her on this. And if that is the case, that language should be pulled out. I certainly support that.
If recognized, Mr. Chair, that will be my motion, that the language that was deleted be restored and this addition remain as it is in the committee sub.
So the motion is to restore the deleted language and leave the language in lines 18 and 19 about a summary to remain in. That's the motion for the amendment. Okay, any other discussion on the amendment? All in favor of the amendment, say aye.
Aye.
All opposed? Okay, the amendment carries. Okay. Then if you look over on, lines 85, that's where we're talking about by the boards of trustees of public hospitals or committee thereof. And so that simply is more or less a technical amendment. So do we have a motion on the amended or the committee substitute? Motion is title sufficient, do pass committee substitute. All in favor, say aye. All opposed? Motion carries. Okay, thank you. Let's see. Next, want to call up Senate Bill 2621, and also in calling that up, you see on your agenda is the discussion items, and Senator Hobson and Senator Blackman, if y'all don't have the agenda on the discussion, are 4 bills, 2213 dealing with divorce, 2220 child support, to continue past the age of majority, which is Senator Parker's bill, 2264 child support, to add income of custodial spouse to the criteria, and Senate Bill 2875, child support. The task force, what that bill is doing is to create a task force to study these issues along with other domestic law issues. In committee, in the bills that were sent to the committee, there's quite a few bills dealing with these issues of child support. Senator McCon has one dealing with no-fault divorce. We've done some research, and interestingly, what the research has revealed is that, yes, Mississippi is one of only 10 states, if not less than that, that continues to use the child support formula that we have right now. 44 other states use a different version, and those different versions generally about looking at the income levels of both parents, also how it affects them. So, and I think I'm not I'm not saying anything anybody doesn't know about what we've discussed in the legislature about no-fault divorce, and Senator McCon has a bill where he's had judges that have talked to him about, they're being put in a position where both parties honestly are at fault in the divorce under our fault grounds. So let me pull this up. So the idea was to create this task force with members who are familiar in this area of the law to study these areas, to present back to the legislature about what we can do to address these. And the task force, the way it's drafted at this time is chairman of Judiciary A committees of the Senate and the House, a designee from the Supreme Court named by the Chief Justice, 2 sitting chancellors, 3 practicing attorneys in the state with expertise in the area of domestic relations, 2 practicing guardians ad litem. And let me say this would also be to include, I personally, and probably all of you have heard issues dealing with guardian ad litems. I talked to Senator Barrett about that. And the idea would be to get, to have that looked at as well. Also, a designee of the child support unit of CPS. I can't begin to tell you the issues I've heard about collecting child support and how that goes. And also a professor of law with expertise in domestic law from the University of Mississippi, maybe Debbie Bell, somebody like that. So, and also from Mississippi College School of Law, and to meet and to go over these issues that I think are pressing on our chancery system and on that. So, and I will say this, I'm not one to say that I have all the who should be on here and everything like that. I will say, I think if you get a task force that's beyond, you know, if it gets too big, you can't get anything. So, and also there may be some other issues that we needed to discuss. Senate Bill 2220 on your agenda is from Senator Parker, who has explained his bill is about child support being paid by the non-custodial parent when there's a special needs child. And if you want to talk about that, you can certainly do that, Senator Parker. But the idea would be including that as well.
Right, and I'll just mention it briefly, and then I'll have an amendment at the proper time. The issue as it stands, you mentioned another issue where over 40 states are now doing something we're not. And on this issue, as of 2015, there were 32 states and territories that were recognizing some type of disability beyond the age of majority as something that a judge can consider in extending child support beyond that age. What we've learned, and I've shared with the chairman, is that there has been Supreme Court work on this before, and I've had the opportunity to talk to at least one previous Supreme Court justice about this issue, and I think it would be nice, having had someone who's kind of seen that come through, to consider as a 10th member of the board, a retired or no longer serving justice of either the Supreme Court or one of the higher courts that deal with domestic law, who has maybe seen this issue in front of them in the past. So that's just a brief explanation. I have a lot of information on it, and I thank Senator Wiggins and Senator Hobson for discussion on this in the past. And, you know, I'll be glad to answer any questions when I make my amendment at the appropriate
Well,
time.
now's a good time.
So moved on my amendment. My amendment would be to add a either retired or no longer serving justice of the Supreme Court or justice who has previously worked in domestic law. And the hope would be we could find someone with a little bit of background who's maybe seen this issue before them in court before, who could share.
So let me ask you on that. So is that in addition to, if you look at line 17, there's a designee of the Supreme Court to be named by the Chief Justice, and then, let's see, I guess that's the only one. So that could be included in there, but if you want, I guess, in addition to what that says right there.
Right, and you
Okay.
know, the current Supreme Court or whoever is making that determination may not have seen that issue, and they won't have the information from this meeting to make that selection. So I would just like to see that just a little more clear. I can come up with some better language as well with counsel, but we're looking, in my opinion, for someone who has some experience or has at least dealt with that for many years.
Okay, so you've heard the, any discussion on the amendment?
I have a question. Senator Parker, I think your amendment and where you're going with it, I'm fully with you on that. However, could you possibly tweak that just a little bit? There are a number of attorneys who specialize in disability law and looking at trust issues and things like that, and know really about what all would actually need to be encompassed into a change in this, and I'm fully supportive of a change. So could you tweak that a little bit?
I would consider that a friendly amendment to the amendment, and again, the purpose of the amendment is to try to insert someone into the task force who who really takes this issue and gives it some strong consideration based on their prior service. And if it's okay, Mr. Chairman, I would love to get with Senator Boyd and put that into
So you're revising your amendment to reflect what she's doing?
revising my amendment to
Okay.
reflect Senator Boyd's comments.
Okay. Any other discussion on the amendment? We'll vote on the amendment. All in favor, say aye.
Aye.
Aye. All opposed? Okay, the amendment carries. All right, we're on the committee substitute. Any other discussion on the task force or the bill itself? Yeah.
And I appreciate where the chairman's going with this. This is the second year in a row that we've kind of looked at some of this stuff. I do have one concern, and I don't know how to address this, Mr. Chairman, but the 3 practicing attorneys, too often we lose the general practitioners in there. And being one, sometimes we lose sight of the people who are actually hurting here. And I have no idea how to fix this in this bill. I have faith in our system that we're going to get some guys and ladies involved in this that are going to look at both sides from the general practitioner standpoint and from the ivory tower standpoint, so we get a good end product. And I'm not sure there's any way to amend that, but that's
You
the
mean
only
like
comment.
actually non-attorney litigants or somebody like that?
No, Lord, no.
Oh.
All I'm saying is that you've got the practitioners who
Oh.
are in a small-town practice, seeing these people every day, and then you've got the people that are representing individuals who have plenty of money to spend.
Oh, I see what you're
You
saying.
see what I'm saying with that? And I'm not sure how we could fix that with those 3. If we come up with something, that would be the only thing I would suggest. If we could figure out something different on the floor, we could potentially do that. But otherwise, I've got faith in the system there.
I tell you, I certainly see what you're saying on that. Maybe working with council. Look, I'd be open to doing a floor amendment on that, and just look. I think general practitioners do that. They don't. I mean, they get expertise because they're doing it, and I see what you're saying about the expertise on there. So, I'm open. If you want to do a floor amendment if this passes, that'd
Yes.
be good.
Thank you.
All right. Okay. Do I have a motion on the committee substitute? Motion is title sufficient, do pass, committee substitute. All in favor, say aye.
Aye.
All opposed? And that passes. Okay. I want to call up Senate Bill 2607. I will tell you up front that the committee substitute is for a reverse repealer in this bill. And what this is a few years ago, Justice Waller, at the request of the Children's Commission of the Supreme Court, called for a statewide county court system. Many of y'all probably have experience in the county court system. The purpose of the reason why they wanted that is because part of it is that the youth court, or you got referees and there's places that don't have this. Part of it was to address better jurisprudence for our youth court cases and our youth court matters, as well as you probably know, your county courts use rules of evidence, all of that kind of good stuff. Personally, they seem to run pretty good, which I think is why they do that. And for the more rural areas, the idea of the bill, and this was pushed, the bill that I filed is actually just revising what Chairman Tollison had filed a few years ago. And the idea is that in those more rural areas, to combine a 2 or 3 counties, have that done. And you can see through the bill in here, this bill has been double referred to appropriations. I have talked to Chief Justice Waller, who supports this bill. Of course, Justice Beam and the commission, John Hudson, who are all working on that, believe this is needed. I'll be honest, I'm not sure why it didn't pass back then. It may have been money. I will say, if we can figure out the money, I think it would be something good. So I put the reverse repeal, the committee sub is a reverse repealer so that we can continue to work on this. I will tell you, I've had meetings with Chairwoman Cockerham on the House. I think they're very interested. She's very interested in working on this. So I think that if you can look at the bill, and I will be upfront in saying that, you know, there are districts that are mentioned in here, and so you can look at your districts and how those are done. But I will say that the commission came back a couple years ago and made these recommendations, which is based on what they were hearing from the district, from the Chancery District. So with that, I will open up to any questions, obviously, and comments. Right. All right? Yeah.
If you don't mind. I do have some concerns here. I remember this coming up. I was not in the legislature, but I do remember every youth court judge in the counties around called me and asked, what are we doing? And I said, I'm not even there yet. My concern is when I look at my districts, which is going to be 23, 24, and 25, it seems to me like we did not take account Chancery districts. In this situation, you have Kemper, Neshoba, and Newton. While I love Senator Branning to death, our districts are not exactly perfect with regard to our Chancery, because hers is going to be, Neshoba is going to be up separate from the Newton County. And while a county court is a hybrid, and then it takes in some Chancery matters and some circuit matters, I am certainly excited to see a county court system, but I don't know that this is the right way to go. An individual county court judge sitting in Kemper County trying to sign a youth court emergency order in Newton County is going to be a good 45 minutes to an hour away from the location. So is that
I'll add this, and probably Chairman Hobson can weigh in on this. This committee, for better or for worse, is charged with judicial redistricting.
And I'm wondering
and
that-
actually, if I'm not mistaken, was to come up, it's not this year, but it may be next year. Senator Hobson maybe can weigh in. And he, to his credit, when he sat in this chair, he handled that, did a good job. I think to your point, the way districts are organized now probably need to be looked at. And I don't know if we're putting the cart before the horse,
And that may be it.
but I think that judicial redistricting is going to come before this committee. Senator Hobson, you have any comments on that?
Thank you, Mr. Chair. I don't want to say too much, but I think that when you take on the task next year, I believe it is, of doing judicial redistricting, I just would suggest that all cards be on the table, all options be out there, and I think that's one of the discussions that needs to be had, is where do we need Chancery, Circuit, county courts, and in addition, are there ways to make them make a little bit more sense, like coterminous Chancery and Circuit courts, but that's a little bit down the road, but I would be careful about piecemealing anything, and we can talk about this more, so that's all I'll say at this point.
And so that may be what you're talking
And that's
about.
fair enough, and the reverse repealer will assist. But those are my concerns looking at those districts there, Mr. Chairman.
Who knows, maybe we can get a jump start on redistricting. How, our judges would like that, wouldn't they? So, okay, any other questions or comments? Senator Turner Ford.
Thank you, Mr. Chairman. It's just a quick question. Did I understand you to say that the designations for county courts, starting at line 53, that these are recommendations by a task force?
So, and I can get that information. So yes, a few years ago, if you're familiar with the task force, and they've brought different bills before the legislature, John Hudson and Justice Beam, they studied this, and they have the reports where they said, where they looked at the jurisprudence going on in this state. I mean, I'm upfront about it, that they said that in more rural places, you got referees, you don't have full-time judges, that the juveniles are not getting what they're should be getting. Also with all the stuff that's gone on with the, I guess I don't know if it's Olivia Y, but the lawsuits that are going on that we've been trying to address, this was part of it as well. And this actually prevents us from going down the road of another lawsuit from the feds and all of that kind of stuff. So Yes, they studied it, and they had these recommendations at looking at that, and yes, Justice Waller in the Supreme Court had supported this to bring a better, lack of a better term, a product for the youth court system in particular on doing that. Okay, do we have a motion? Motion is title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? All right, that carries. All right, we'll go to Senate Bill 2086, and we've addressed this, the legislature, the last couple of years. Many of us have children's advocacy centers who do the forensic interviews for alleged, abuse and things like that. The operative language is item line 78 to 86. While I can't understand it, there are places in other states where these forensic interviewers and all have been sued, and not sure why, but they have. And in Mississippi, the children advocacy centers perform this function for law enforcement, for DA's, for DA's offices, things like that. And so the idea is that a member of the multidisciplinary team and a child advocacy center is not liable for any civil damages. And let me be clear, because I had a question on it. This is the language where it says within the scope of official team duties, and that means doing the interviews, if they get a referral, handling the case like that. It's not anything dealing with premises liability or anything like that. So this is actually carrying out your official duties, and I guess official duties as a member or an employee of the Children's Advocacy Center is within the scope of that. So that's what the bill does. So have any questions on that? Senator Simmons.
Thank you, Mr. Chairman. And I think you cleared it up in your explanation, but certainly in those situations where an abused or neglected child is injured at the center for some act or omission of one of the agents of the center, we are not trying to immune that type of conduct or behavior, are we?
That is not the purpose of this bill as drafted, and working with the children advocacy centers. I know Senator Parker has one in his area. They've not told me anything like that.
Thank you, Mr. Chairman.
Thank you. Okay. Any other questions? Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? No. The ayes have it. Let's see. Okay. That'll pass. Let's see. All right. With that, and we have the one tabled subject to call. That remains on there. And as far as our agenda, that's good. So do we have a motion? Rise and report. We will meet Monday at 2:30. All in favor, say aye. All opposed. Rise and report. Thank you all very much. Appreciate it.